Having talked about basic legal issues, let's take a little deeper dive into some copyright basics. It's in the Constitution, Article 1, Section 8, Clause 8, to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That's us. It's intellectual property. There's three major types of intellectual property. You have copyright, which applies to photography. You have patents for inventions, and you have trademarks, which are for things like Coca-Cola or McDonald's. A copyright notice must be attached to copyright images. There are three elements to a notice, either the symbol or the word copyright written out. And you can get that symbol with option G on a Mac. It's a nasty ASCII code on a PC, so my suggestion is cut and paste it. You need the year the photo was taken, and you need the name of the author. And you want the full legal name of the author, so if you're first and last, if you might be confused with somebody else, maybe a middle name. Some examples would be copyright 2020 Colorado State University or copyright 2020 John Isley. Who owns the copyright? It seems pretty simple. The author owns it. But if you're an employee, your employer owns it. Your employer is the author if it's within the scope of your work. If you're a freelancer, the photographer owns it, absent a prior written agreement. That agreement has to happen ahead of time for the employer to own it, unless it's a work for hire situation. Watch for those magic words in a contract. A work for hire means that the client owns the images. California now requires work for hire clients to act like employers with giving you a W-2 and workers' comp insurance. It's a written agreement that says you're an employee of the client during the project. The client owns the copyright. There is nothing for you to license. You have no rights to the photo, not for your portfolio, not for your website. It's not your photo, and it never was. It was intended for things like movies, where you'd have a large crew working on a single project, and publications have adopted this as a way to get control over photographs. When does the copyright come into being? As soon as it's written to the card, it has to be a fixed artistic expression. It can't just be a good idea. It can't just be your vision of how something could be. It has to be a tangible, meaning you can touch it, artistic expression. How long does it last? When the law was first written, it was good for 14 years, renewable for another 14 years after the creator's death. It was extended to life of the author plus 50 years. And in 1998, the Digital Millennium Copyright Act extended that to life plus 70 years. Thank you, Mickey Mouse, because the DMCA was passed right as the life plus 50 was beginning to expire on Mickey Mouse. You can register your copyrights with the Library of Congress. Why bother? Well, if you have an unregistered infringement, in other words, somebody steals your photo, you're entitled to actual damages. So in other words, if they stole your photo and you'd have charged them $200 for the use, you're entitled to $200. It's difficult to get a lawyer for those kinds of fees because the payouts are very low. If you have a registered infringement, you get statutory damages written into the law. If it's proven that it's a willful infringement, they knew it was your photo and they used it anyway, it can be up to $150,000 per infringement plus the attorney's fees. If they've used it twice, maybe once in a publication, maybe once on a website, that's $300,000. Now you can get a lawyer's attention. If you're infringed, stop talking about it and call a copyright lawyer and do what he says. Don't post things onto message boards and onto your Facebook page and onto the internet. Stop talking about it. How do you bother to register? You should register work as unpublished. It's easier and cheaper. You have 90 days after you take the picture to register as unpublished, and 5 years after publication if you want to register it as published work. But published works have to be registered individually and have 2 copies deposited. So it's cumbersome. For an unpublished work, the first of the month, a good workflow is to gather last month's images, export 200 wide pixel-wide JPEGs. They don't have to be huge. And as of February of 2018, there's a limit of 750 photos per registration. Download and fill out the file name template from the Library of Congress's copyright site. It's www.copyright.gov. There's a fee of $55 for groups of unpublished photos. Sometime later, the Library of Congress will send you a registration certificate and add that registration number to the metadata of the images so that, again, if you're infringed, you can go to your file cabinet, pull out the right certificate, and send somebody a nastygram. Copyrights are a two-edged sword. Just like you don't want somebody to steal your photos, you should also avoid infringing on other people's copyrights. So when it comes to avoiding infringement lawsuits, it's not just enough to credit the creator. You do need explicit permission from the creator. And in some cases, you may have to pay royalty payments or licensing fees. And again, this cuts both ways. Be careful with photo contests, lastly. This was a Sierra Trading Post contest entry. And if we read in the rules, the entrant's grant of rights, by participating in the promotion, each entrant irrevocably grants the sponsor. And by that, it means just by entering. You don't even have to win for this to happen. And its agents, successors, and assigns a non-exclusive, unlimited, worldwide, perpetual, royalty-free, transferable license and right, but not the obligation. So they can do whatever they want to, whenever they want to. They can even sell your photo to somebody else to reproduce, publicly perform, distribute, exploit, publicly display, and otherwise use the submission in any way for any reason and in any and all media, including but not limited to the contest site. So again, they can license your photos for something else. If they decide that you send them a nice landscape and they want to hang it in their store, no problem. They're allowed to do that. If they want to license your photo to Hilton Hotels to put in hotel rooms, they can do that because you've just given them the right. It goes on to say without limitation, without further notice, consent, or consideration to the entrant, meaning they don't have to pay you anymore. Without in any way limiting the foregoing, the sponsor shall have the right at its sole discretion to modify and make derivative works of the submission for any purpose. Meaning they can cause your photo to put somebody in a libelous situation, which the sponsor deems necessary or desirable, and each entrant irrevocably waives any and all so-called moral rights they may have within, which means you can't even object. Sponsors shall have the right to freely sublicense its rights that are under, which means they could sell these rights to somebody else, in whole or in part to any person or entity. Sponsors shall retain the rights granted in each submission, even if the submission is disqualified or fails to meet the submission requirements. They're not looking for a photo contest. They're looking to build a photo library of photos that they can use and license out for other uses. This, to me, is not a legitimate photo contest. So if you're looking at contests, read those grants of rights very carefully and be sure that you understand what you're entering.